I would like to welcome you to our webinar on relocating with your child, what happens when there's family violence, which is hosted by METRAC, Action on Violence, with our guest speaker, family law lawyer Stephanie Okola. My name is Andrea Collins-Fitzpatrick, and I'm the legal director with METRAC. I would like to begin today with a land acknowledgement. We acknowledge that this land is traditional territory of many nations, including the Huron-Wendat, Haudenosaunee, and the Mississaugas of the Credit. Today, the meeting place of Toronto is still home to many Indigenous people. We honor all the First Nation, Métis, and Inuit people living on this land. We recognize the traditional territories on which our organization is located and on which our programs and trainings take place. I would like to remind you that this webinar is for general information purposes only and is not legal advice. The legal information provided is not intended to be used as legal advice for a specific legal problem. This webinar will be recorded and reflects developments in the law before today, March 27th, 2025. It will be posted on our website at onefamilylaw.ca. That's onefamilylaw.ca, along with PowerPoint slides. Stephanie has also kindly prepared a case list summary, which we will be sending to all participants after the webinar today. We will have time for questions at the end of the presentation. Before I move to our presenter today, I would like to tell you a bit about METRAC. As many of you know, METRAC works to end gender-based violence across communities through education, research, and policies. We have been in existence since 1984, so this year it's going to be 41 years, and our programs are devoted to advancing safety, justice, and equity. METRAC's Community Justice Program provides legal education and information related to gender-based violence, and through our Access to Justice program, we provide legal information in areas of family law, immigration law, criminal law, employment law, and human rights law. This webinar is part of our Family Law Education for Women, FLU, series. FLU's resources are available in 14 languages, ASL videos, and accessible formats. You can visit our website at onefamilylaw.ca, onefamilylaw.ca, for more information on any family law matters that you or your clients may have. I'm very excited today to have Stephanie Okola to speak to us about relocating with your child, what happens when there is family violence, and thank you all for joining us today. Before I introduce Stephanie, I would also like to thank Kenyan, our Justice Program Coordinator, for running the PowerPoint presentation today, and as always, our technician, Ferdinand. So I'd now like to introduce Stephanie. Stephanie Okola is a passionate litigator and advocate practicing in the areas of family law, including fertility law, child protection, and appeals. She has appeared before all levels of court in Ontario, including the Ontario Court of Justice, the Superior Court of Justice, the Divisional Court, and the Court of Appeal. Stephanie is also a trained mediator, focusing her mediation practice on community-based mediations and contested decision-making and parenting time orders. Stephanie is a staunch advocate for access to justice and community legal education. She is active in several community outreach organizations and volunteers her time as a legal educator in primarily low-income and disenfranchised communities. She previously worked alongside Legal Aid Ontario and members of the Black community to establish a new community-based organization to deliver legal services to Black Ontarians who experience anti-Black racism. Stephanie is also a member of the North Toronto Family Court Education Committee, which provides high-quality, affordable, continuing professional development for members of the family law bar. In her spare time, Stephanie is a dedicated mother and partner, amateur home cook, and travel enthusiast. Please enjoy the presentation today, and thank you so much, Stephanie, for being here. We do appreciate it. I'll now pass things on to you. Thank you.
Thank you, Andrea, for that lovely introduction. I hope everybody can hear me clearly. So today I'm going to talk to you about relocation, which remains one of the most difficult issues in family and parenting cases for counsel and for self-represented parties, and particularly in circumstances where there's been family violence. It is a very hard topic to sum up in a 1 hour session, but I'll do my best. My aim for today's webinar is to give you a good starting point more than anything else from which to work at if you are preparing for, responding to, or dealing with the issue of relocation in a case where there has been family violence. I'm going to start with the general principles of relocation and the changes to the legislation. Before 2021, the issue of relocation was defined, or mobility as it was known then, was defined in a Supreme Court case called Gordon and Gertz. I do have a cite on the slide, but in the document that I send out afterwards, it'll contain all of the case laws with the proper cites. So don't worry about noting any of that information down if I mention a case. So I'm going to start with the most obvious question, which is, what is relocation? A relocation is more than a mere move. It must impact parenting arrangements in a way that is significant to the other party or parent. Relocation is not the same thing as a change in residence. A change in residence will refer to a move that is not significant to the other parent or the other party, and whether this move is significant is assessed on a case-by-case basis. So for one person, a move to a town over may not be significant, but for another family who may have, say, transportation issues, it may be significant and constitute a relocation. For many years, lawyers and judges alike relied on the legal test for relocation, or again, mobility as it was known, as set out in Gordon and Gertz. The legal test in Gordon and Gertz required judges to consider multiple factors in relocation cases, including the merits of the requested relocation case, and it emphasized that the custodial parent, as it was known then, their reason for moving should only be considered in exceptional cases. The Supreme Court further held in that case that the issues of relocation are to be determined on a case-by-case basis in accordance with the best interest of the particular child being dealt with in those particular circumstances. There was no legal presumption in favor of the custodial parent, although the views of the custodial parent were entitled to great respect. Both parents bore an evidentiary burden for demonstrating whose plan was in the best interest of the child, and the Supreme Court affirmed that the best interest of the child was the only appropriate legal test to apply at that stage. The courts considered many factors, including the existing arrangements and relationship between the child and the primary or custodial parent. I'm going to use the words custodial and decision-making interchangeably because before the changes to the legislation in 2021, we referred to it as custody. The existing access, or now we call it parenting time, arrangement and the relationship between the child and that parent, and then the desirability of maximizing contact between a child and both parents. They considered the views of the child, if those were reasonably ascertainable, the custodial parent's reason for moving, only in an exceptional case where it was relevant to that parent's ability to meet the needs of the child, the disruption to a child in the case of a change of custody, the disruption to a child as a result of removal from their home, their family, their schools, their community, or what he or she has come to know. In 2021, there were extensive amendments to the Divorce Act and to the Children's Law Reform Act. These came into effect on March 1st of 2021. One of the most important amendments within the legislation, the new legislation, established a new legal framework for relocation cases. The changes to the Divorce Act are reflected in Section 16 sub 9 of the Divorce Act, and in the Children's Law Reform Act, relocation is contained primarily within Sections 39.1 to 39.4. The first major amendment made in the legislation post-2021 is the notice requirement. So prior to the legislative changes in 2021, a party who was seeking to relocate with a child did not have to give formal notice. The amendments to the Divorce Act and the Children's Law Reform Act now require those who have decision-making responsibility, parenting time, or contact with a child, and who are looking to change their residences or to relocate, whether they're doing this with or without a child, to provide formal notice. This notice must be in writing, must be set out with certain information, and this information is all prescribed within the legislation, and it must comply with particular deadlines depending on the circumstances. The amendments also permit a non-relocating party to object to that relocation formally. If no objection is made in accordance with the legislation, then the person who intends to relocate may do so as long as there is no order prohibiting the relocation. If there's a formal objection that's provided within the timeline set out in the legislation, then the party who intends to relocate cannot do so without the issue being resolved. The notice provisions in the amended legislation are applicable only if there's an existing order or agreement under the Act that relates to these parenting orders, so decision-making, parenting time, and contact. To an extent, the legislation also reverses parts of Gordon and Gertz in that it requires the courts now to consider the reason for the move. A further important change is that it sets out that if a pre-existing parenting order or agreement restricts the relocation, this is a factor to be considered when determining whether or not to authorize the relocation of a child. Importantly, the amended legislation will direct a court to consider the best interests of a child when it is making any orders for relocation. It is important to note at this juncture that another major change to the legislation from 2021 was the introduction of the concept of family violence as an important factor to consider when making a determination about the best interests of a child. So prior to 2021, the best interests of the child test laid out that the conduct of a parent was important in determining parenting arrangements. But the conduct of a parent was not the only issue that a court should consider when making a determination of the best interests of a child. It was but one of the factors. Family violence itself was not explicitly defined within the legislation, but it was encapsulated within that conduct provision. So if a parent's conduct constituted violence, then that conduct could be considered in the context of determining the best interests of a child when the court was making a parenting order. With the post-2021 changes, family violence has actually been incorporated meaningfully into the best interest test and into the legislation. Family violence is now broadly defined in the legislation, and it includes the following. 1, family violence could be violence, meaning any conduct by a family member towards another family member that is considered violent or threatening, that may constitute a pattern of coercive and controlling behavior, or that may cause the other family member to fear for their own safety, the safety of another person, or in the case of a child, may include the direct or indirect exposure to such conduct. For the purposes of that definition, the conduct does not need to be a criminal offense and includes physical abuse, and that physical abuse can also include forced confinement or restriction of somebody's movements, but it does not include the use of reasonable force to protect oneself from another person, so self-defense. It can include sexual abuse of all forms, threats to kill or threats to cause bodily harm to any person, harassment, including stalking, failures to provide the necessaries of life, psychological and emotional abuse, financial abuse, the threats to kill or harm an animal or to damage property, and the killing or harming of an animal or the damaging of property. These changes are very important to note because the broad definition of family violence allows practitioners or self-represented parties to present to a court different facts or different scenarios that they may have encountered that sort of fall within the umbrella, this broad umbrella of family violence. Post-2021, after the changes were made to the legislation, further changes were made within common law, and the most important case to know is a case named Barendrecht and Grebliunas, and I apologize if I'm mispronouncing the name, but again, I'll provide the full cites in the document that is sent out after today's webinar. So after the legislative changes in 2021, the Supreme Court further refined the legal test for relocation within common law. This case modified the principles within Gordon and Gertz regarding relocation so that they could be brought in line with the relocation provisions that were set out in the amended legislation. Barendrecht highlights several very important principles, and I'm going to talk about a few of them. The first is that the history of caregiving will be relevant and sometimes warrants a burden of proof in favor of one parent or another. So if you're dealing with a case where one parent has clearly been the primary caregiver of the children for a significant period of time, the court can consider this an important and relevant factor and give the parent who has been the primary parent, or tilt the balance in favor of the parent who's been the primary parent. Second, a parent who intends to relocate does not need to prove that this move is justified, and a lack of a compelling reason for the relocation does not count against the parent, or should not count against the parent rather, unless it reflects adversely on that parent's ability to meet the needs of a child. So, for example, if a parent who's choosing to move is moving simply because they don't want to live there anymore, or they want to experience living in another city, the court doesn't necessarily hold that against the parent. It doesn't have to be a compelling reason. Unless there's behavior exhibited by that parent or actions taken by that parent that indicate to the court that it's going to impact their ability to meet a child's needs. Reasons for the move must only be considered to the extent that they are relevant to the best interests of the child. This is an important one, and that is avoiding family violence or acrimony can be a very important best interest factor in determining relocation. Courts have also recognized that a child's best interests are furthered by a well-functioning and happy parent, and this is related to an extent to the concept of family violence, because oftentimes people who are experiencing family violence are also experiencing other effects of the family violence upon their lives. So, for example, they may be experiencing changes to their mental health, changes to their stress levels, changes to their physical health as a consequence of the family violence that they have experienced. And so the court may consider that relocating with a child where there has been significant family violence is part of the best interest calculation, because the relocation can impact the health and safety of their caregiving parent. A relocation that may provide a parent with more opportunities, education, employment, and economic stability can contribute to a child's well-being. And this is another factor that within Barendrecht, the court said must be considered when dealing with relocation cases. All of these considerations can have a direct or an indirect bearing on the best interest of a child. The additional support of family and community at a new location, which could enhance a parent's ability to care for the child or the children, can also be considered in the context of a relocation. Importantly, they also noted that it can be difficult to disentangle the interests of a parent from the interests of a child. A child's welfare is often tied to or in tandem with the improvements in a parent's life, including their financial and social and emotional circumstances. With respect to the issue of family violence itself, the Supreme Court in Barendrecht made several comments about it. The first comment they made is that the amendments to the Divorce Act, and now by association as well the Children's Law Reform Act, recognize that findings of family violence are crucial considerations when dealing with best interest analysis. They further commented that the suggestion that domestic abuse or family violence has no impact on children and has nothing to do with a perpetrator's parenting ability is not a tenable suggestion. Social science research has indicated that children who are exposed to family violence of any nature are at higher risk of emotional and behavioral problems through their lives. And this literature was finally recognized by the courts and within the legislation when making those changes. Harm that can result from direct or indirect exposure to domestic conflict, for example, observation of incidents or being present when incidents are occurring, hearing verbal or emotional abuse, experiencing the aftermath of this abuse or hearing about the abuse after it occurs, can have a significant impact on children. As a consequence, the court must consider family violence seriously when considering any best interest analysis. In Barendrecht, the court further noted that domestic violence allegations are notoriously difficult to prove. Family violence often takes place behind closed doors and, in many instances, lacks corroborating evidence or witnesses. Sometimes family violence can last the length of a relationship, or it could be a short period of family violence. It often doesn't have supportive evidence in the way people may think about evidence that a court may require, so written information. Also, types of family violence, like coercive control, are not often readily visible to third parties. Proof of one incident may raise concerns for a court for the safety of a victim, or may overlap with and enhance with other best interest factors, such as maybe the need for limited contact or support. So the changes to the legislation and then the affirmation of these changes and the refinement of the common law test in Barendrecht also did away with the concept that there has to be maximum contact between a parent and a child. And rather, the court now relies on a parenting time factor. So a refined principle that's less focused on a child having maximum contact with each parent and having parenting time with each parent that is reflective of that family's needs and circumstances. So what do these changes mean? Simply put, there is now both a clear statutory and common law framework to consider in relocation cases. And family violence is a specific factor that has to be considered as part of that framework. Next slide, please. So in discussing important factors that should be considered in relocation cases, the first factor I'm going to start with is notice requirements and when they apply. You have to think about if a relocation is being considered in the context of an initial court application, or if it's a variation application to change a previously made parenting order. If a relocation is being done in the context of an application, there are no automatic notice requirements. If it is being done in the context of a variation application, where there have already been parenting orders made, there are. From a practical perspective, in my experience, I find that providing notice, especially when the other parent is having contact with the children, even if it's not contained within a court order or an agreement, providing notice is helpful for the relocating parent because it shows the court that they are serious about making sure they maintain that relationship with the other parent. If there are no provisions for parenting or contact within a court order, and the child is not spending any time with the other parent, the non-relocating parent, then those requirements, in my experience, I don't find it helpful to provide notice in those circumstances because that parent isn't exercising time with the child or having contact with the child in any event. The court must also consider what existing parenting arrangements there are. So, is there a court order? Is there an arbitration award? Is there a separation agreement or a parenting agreement? Is there a kitchen table agreement between parties that they've been using for a long time? Are the agreements between the parties formalized? Did they have independent legal advice? Are they contesting what the parenting arrangements are? Are there questions about one parent withholding the children from the other parent? Are there concerns about one parent not following a court order or agreement? So the court has to consider all of those fact-specific questions when making a determination about whether or not a relocation is in the best interest of a child. In terms of preparing for any case where you're dealing with relocation, it is important to understand that historical context and provide that context to the court, both in the form of the pleadings that you provide to the court, as well as any affidavit evidence or further evidence that might be required if it ever goes to a hearing. But all of the previous arrangements and historical relationship between the parents and the children are going to be considered relevant when making determinations about relocation. Are there any child support obligations? So a court can consider if there are existing child support obligations. Is that support being paid? Are the orders being followed? Are there informal arrangements that parents have made with respect to the payment of support or the provision of support? A parent's improved ability to satisfy a child's needs, including financial viability, is a valid and compelling parenting-based reason for the move of a primary caregiver. So if you are in a circumstance where you're assisting a party or you are a party who is a primary caregiver of a child, you have been the person who has provided primarily financially for the child, either because the other party isn't paying support or has chosen to not follow a court order, or is paying less support than they're supposed to and has refused to pay more support, for example, then in those circumstances, the court can consider a move or a relocation in order to help you with your own financial viability as a compelling reason for a move. On the issue of family violence, the court also considers criminal convictions, charges, or accusations and questions of credibility. This is extremely important. It's not just circumstances where a party has been charged or convicted of criminal actions against the relocating party. It's also other criminal convictions that may count. Further, those are not the only circumstances that a court considers when determining family violence. So criminal conviction or charges are not necessary. The court can consider if there have been civil restraining orders, if there have been long-term no contact orders, and if those orders have been violated. And the court also considers the credibility of the parties when making accusations of family violence. And this is particularly why arguments about family violence can be very difficult, because oftentimes the instinct is to believe that documentary evidence or oral evidence from third parties who are reliable is required in order to prove that there's family violence. There's a significant body of case law that says that family violence need not be proven in that sort of traditional fashion, meaning a court can assess the credibility of the parties who are providing evidence to them and determine that there has been family violence without the benefit of that additional sort of evidence. So without there being any criminal convictions or charges, without there being any civil restraining orders. The court can even consider that there's been family violence in contexts where the accused person has been found not guilty of family violence or a form of violence, assault against the party who wants to relocate, and that person's credibility has been brought into question. I recently dealt with a case myself at the Ontario Court of Justice at 47 Shepherd, where that was one of the primary issues. The court considered whether or not the father, who had been found not guilty of assaulting the mother in this case, and the mother was the relocating party, the court considered all of the evidence that the parties provided at the family trial in terms of determining whether or not there had been family violence. And they found that there had been family violence, and there didn't need to be a criminal conviction to prove to them that there had been family violence. They went off of the evidence that was provided by the mother during the trial. In those contexts, it's really important to make sure that the evidence of family violence that presented to the court, or your client who's presenting that evidence, is presenting credible evidence and honest evidence. So ensuring that the information that's being provided to the court is not exaggerated, that your client, if they're testifying before the court, is providing evidence that appears to be honest and credible, and ensuring that you, as far as possible, can provide, if you can, because it's not always possible, but if you can, provide information with times and dates where this may have occurred. It is important to note that even though family violence is a consideration in relocation cases, it is not the only consideration. So even in circumstances where there has been significant family violence, the court has to hear other evidence related to the best interest of the child test. It is not the only factor that they consider. So they must still hear evidence about the existing parenting arrangements, as I talked about earlier, or if there are previous court orders that exist, and the child's relationship with the non-relocating parent. Sometimes when there's been significant family violence, particularly, people focus on the element of family violence alone in relocation cases, but having the other information about the other factors actually strengthens your case, because oftentimes in circumstances of family violence, there are clear imbalances of power within the relationship, and those imbalances of power within the relationship often reflect themselves as parts of the other best interest considerations. So, for example, in circumstances where one party is completely financially reliant on the other party, often the person who's financially reliant on the other party is the person who is the primary caregiver of the children. It doesn't happen in all cases, of course, but it's often the situation. And often when they are the primary caregiver, they have a closer relationship to the children. Or the parenting arrangements post-separation have it such that the children are residing primarily with them. So the elements are connected to each other, and it's important when making a claim for relocation that you connect all of those dots. The court can also consider blameworthy conduct by a party who is wishing to move. What I mean by blameworthy conduct is if you are dealing with a party who has defied previous court orders for, say, parenting time, or has withheld parenting time, has unreasonably refused contact between the other parent and the children, the court may consider that in the context of a relocation, because a relocation can cause a gap in the relationship between the non-relocating parent and the child. Next slide, please. Distance matters. So as I spoke about earlier, there is a difference between a relocation and a change in residence. And it must be clear from whatever information you're providing to the court whether or not the move impacts the child's relationship with the other parent. So it's not enough to say, I've moved a long distance. There may be circumstances where that doesn't really matter because the other parent's time with the child is limited, or the parents have come to an arrangement where they maybe meet in the middle to assist with transportation. And there may be circumstances where a move is not that far in distance, but has a bigger impact on any sort of parenting arrangements, perhaps because the parties don't have a vehicle. They rely on public transportation. They're moving to a location where there's no public transportation, reliable public transportation available, or alternatively, that public transportation would take too long. It also matters if one parent has, or both parents have a significant amount of parenting time with a child. The nuance between a relocation and a change in residence is particularly important in those circumstances because generally speaking, the more time a parent has with a child, the more important it is for them to be in a location where they can have their parenting time with a child. The court can also consider the impact of relocation on a child, given the ages and circumstances of a child. Generally speaking, the older the child, the more important their views and preferences are to the court. Now, I've never dealt with a case in which the views and preferences of a child completely are the focus of a relocation application, but the older a child is, generally, the more important it's going to be for the court to understand what the views and preferences of the child are and what impact the relocation has on the child in terms of their social circle, in terms of their ability to continue to attend a school that they might be enjoying, in terms of their activities, for example. It's not to say that relocation doesn't have an impact on younger children, but the voice of the child and the way that the court views the voice of the child is different depending on the age and circumstances of the child in question. The court will also consider the reasonableness of the request for relocation. So if you're assisting a party who's making a request to relocate and their request for relocation does not seem reasonable to the court, and of course reasonable is context specific, then they're less likely to approve the relocation. In my experience, reasonableness is important for things like cost of the relocation to the other parent. So how much is it going to cost the other parent to exercise any parenting time with the child? And will they get any reprieve for the child support that they might be asked to pay? Is it difficult for the other parent to be able to travel to meet the child? Are there barriers to things like immigration with respect to the other parent being able to see the child? Is there consideration of safety where the relocating parent wants to move to? So again, all of these factors have to be considered in tandem with issues pertaining to family violence. And in circumstances where there has been significant family violence that the court has found, they're more likely to provide a parent who wants to relocate with a little bit more wiggle room in terms of the distance than in a circumstance where the request for relocation doesn't have those additional factors. It's also important to consider whether or not a request for relocation is interim or final. So there does not have to be a finding or an order or an agreement that one parent is the primary parent. There does not have to be a finding that one parent is the decision-making parent before a parent is allowed to move on an interim basis. The court, again, will consider the variety of factors that I talked about before in terms of determining whether or not a parent can move on an interim basis, bearing in mind that an interim relocation can naturally have a significant impact on whether or not that relocation is permitted on a final basis. Next slide, please. I wanted to talk about some of the common mistakes I see sometimes people making when they're making claims for relocation in parenting cases, especially when there are considerations of family violence. One, sometimes people think that significant impact of family violence replaces all other factors in the best interest of the child test, and that's simply not true. When the court is considering the best interest of the child, they must consider which of the provisions within the test apply and apply them all. They may give more weight to one provision over another, but it does not replace the other considerations in the best interest of a child test. So there are circumstances where I hear people arguing that because of significant family violence, a relocation should be automatically permitted, even in circumstances where the other parent, the non-relocating parent, has significant parenting time with the child, or is a constant presence in the child's life, or would be significantly impacted, and the child would be significantly impacted by the move. So it's important not to argue family violence as a way that replaces the rest of the best interest considerations, but to make sure you provide the evidence that supports why family violence is an important consideration in terms of the best interest of that child. Oftentimes I hear people ask, is some violence considered to be worse than others in the eyes of the court? And the answer to that question is no. All family violence is important. So as I discussed earlier, the definition for family violence is broad. And the court doesn't just focus on one kind of family violence over the other. I think some people's instinct is to think that physical violence or sexual violence are more important than other forms of violence, when the reality is that there is, again, a significant body of case law coming out now that shows that the courts are recognizing more and more that issues like coercive control, financial control, emotional and psychological violence, verbal abuse, particularly when those issues impact the child as well, are equally important to violence that manifests itself in more visible ways. It's important to make sure that the court knows, rather, all of the fact-specific issues that are relevant when it comes to family violence. So, as I mentioned earlier, the more information you have that is specific, the better. Frequency of the violence, approximate dates when it occurred, not overinflating the information or writing it in an inflammatory way, I should say, noting how the violence has impacted other members of the family, noting how the violence may have impacted either the relocating parent or the children's mental or physical health. All of those are fact-specific issues, which in part make relocation cases difficult to argue because it is hard to tell somebody that the court is going to definitely land on one specific area as a result of a family violence. But the more focused facts that are pled, the better. In terms of preparing any materials for court, I'll just speak from my own experience. It's important, as I said, to be specific. It's important to give detail. It's important to not be inflammatory. It's also important to put the information before the court as soon as you can. So from the time that you draft the pleadings, if family violence is an issue and your client is considering relocation, that information must be before the court at the time that you put your pleadings together. It does not mean that the court will not consider family violence if your client raises that information with you later on in the proceeding, but it does assist with their credibility if you bring up the issue as early as possible, particularly in cases where relocation is a big issue and where that relocation is being heavily contested, because it impacts the credibility of your client. I would say it's also important to understand what the legislative requirements are when you're preparing your materials for court. So if you're assisting a party who is asking to relocate in the context of a variation application or a motion to change, you must ensure that your client has fulfilled the requirements in the legislation to provide the requisite formal notice. And it must ensure that the notice requirements meet what's spelled out in the legislation in terms of what must be contained within the notice requirements. Sometimes that is a difficult task because Oftentimes, parties who are relocating or wish to relocate and have experienced significant family violence from their previous partner are hesitant to share some of that information. They're hesitant to share information about where they are relocating to. They're hesitant to share information about their new address, the child's school information. They're hesitant to share information about perhaps new partnerships. But the reality is that because the legislation is specific when it comes to ensuring that you provide information about the sort of intricacies of the relocation, as far as you can, provide that information right at the start. Because if you provide a deficient notice, even if the court may permit relocation further down the line because other factors prevail, it's going to be a consideration for them. I think it's also important to note that even again, if your client is wishing to relocate in the context of an application, even if there is no pre-existing order or agreement, the court can consider informal agreements between parties or informal arrangements between parties, or as I noted earlier, kitchen table agreements between parties, and say that notice would have helped. It's not required, but notice would have helped. On to the issue of case law. So since 2021, there has been quite a significant growing body of case law dealing specifically with the issue of relocation when family violence is also a factor. I'll start with a case called McBennett and Danis, where the court talked specifically about the broad definition of family violence and the specific inclusion of this factor as a mandatory consideration in determining the best interests of children. It called for courts to recognize the profound effects that all forms of family violence can have on children, and that these consequences can be both direct and indirect if a child is exposed to family violence, and if the victimized parent is impacted physically, emotionally, psychologically, as these consequences often impact their ability to meet a child's physical and emotional needs. As I mentioned earlier, there's case law that indicates that the court can consider all forms of family violence and look at the way it takes shape within each family. They've noted that it can involve coercive and controlling behaviors, which can be difficult to prove because they take place in private, and that abusers, especially those of the coercive and controlling kind, can be skilled manipulators. So they can be charming, they can present well physically or emotionally to the public, they can be convincing liars, they can be persuasive. One of the cases that speaks in detail about this is a case called Volgamut and De Cristoforo. Again, I'll put all of these cases in the document that is sent out later on. Case law also shows that a court may not hold against a party their failure to speak out earlier or inconsistent evidence, as it can be quite common for victims of domestic violence. This doesn't mean that you shouldn't try to plead this information earlier, but it doesn't mean that it sort of is the nail in the coffin for your client's case if you have not pled it earlier. The courts are also more aware now that family violence can be very difficult to prove, and there are many reasons for this. There are often no medical or third-party corroborative reports with respect to family violence. There are often no Children's Aid Society reports or supporting information from parties who are neutral to corroborate family violence. Importantly, a lot of victims minimize the family violence that they experience. And again, family violence can often take place in private where there are no real witnesses. One of the cases that discusses this in detail is called Wiafe v. Aboakwa Yeboah. Again, I'll put this on the list of cases, but it goes into detail about ways and means in which parties who are experiencing family violence, who've not necessarily spoken out about the family violence, how this can impact their families, and more importantly, how the court should consider those circumstances. There are cases that talk about how denigrating your spouse in front of children can fit within the definition of family violence. One of those cases is Amar v. Smith. Another one of those cases is McIntosh and Baker. Cases that deal with violence not needing to be physical, and there could be emotional or psychological abuse, which can have a devastating impact. One of those cases is Dayball and Binag. Another case is El Khatib and Noun. I myself have also argued a few cases with respect to the issue of family violence and relocation, As I mentioned earlier, there's a case I assisted with earlier this year where my client wanted to relocate to the United States with their child. And in this particular circumstance, the father had been found not guilty of assault against my client, who was the relocating parent, but the court still found her to be a credible witness as a result of the way that she gave her evidence at trial, and did not consider the fact that she was not found to be credible in the criminal court to have that impact in the family court when they were making the determination of whether or not there had been family violence and what the impact of that family violence had been. There's also another case I argued a couple years ago at the Ontario Court of Justice at 311 Jarvis, where the issue of relocation dealt with a parent who was not paying any support, who denied that support should be paid for the child, and how that impacted the primary parent and their relocation request. In that case, there were also circumstances where that relocating parent had engaged in what the court considered to be blameworthy behavior, and the court underwent an analysis to determine what the impact of the blameworthy behavior was in determining whether or not they were able to relocate. The court also dealt with different forms of family violence in that case, including verbal and physical abuse, and the impact of that family violence on the relocation application. I could probably talk about these cases for hours, but we don't really have the time to do so. And I would like to give people an opportunity to ask questions if they have any questions. So I'm going to end my presentation here.
Thank you so much, Stephanie. That was very, very interesting, particularly the case law discussion, because I didn't actually know about denigrating a spouse could be seen as, in front of children, could be seen as family violence. So that was very interesting. I'd love to talk to you more about that. But before we moved on, I just wanted to share some resources with the participants. So we just have some resources that will be on the slides that will be posted with the presentation. That is, you can see there's some family law resources that will be helpful for your clients. Thank you so much. I also wanted to mention before we get into questions that there is a survey that I'm going to pop in the chat. If you could please complete that. And now I'm going to hand it over to the participants if they have any questions for Stephanie. Thank you so much.